Hello there, my dear friends. I'd like to welcome you to our resumption of our sharing with you on the beautiful field of law. I have missed you a lot because of the several statics that I had to go through for the past couple of weeks. The 21 quarantine on COVID 19. And as a result of that, when I came back to my iPod, no, this iMac, Apple iMac, I screwed up a lot of things that had the Apple people setting up a new version of Mac OS, this time Catalina. And once Catalina was running, I realized all of my working operating files, especially MS Office, was gone. And I had to assemble all of these, purchase copies. The files have been lost somehow, but the emails are still intact, so I could download many of the files. Many of my legal files are also intact. I normally print exchanges concerning cases. But the long and the short of the story is the technical aspect prevented me from uploading a lot of materials that would have interested you for the past so many weeks, especially for my friends who took the February 2022 bar examination. I had a number of tips and notes. A number of them came out, but I wasn't able to upload them. I guess this effort is to compensate and share with you my own version of what I think should have been the answers to the 4 days, the four major examinations, which were compressed from the original 8 subjects. In all candidness and sincerity, I'd like to reach out and congratulate Associate Justice Marvin Leonen, a former associate among the Philippine Association of Law Schools when I was Secretary General sometime in the mid 2000. I do really appreciate the hard work that he did because this is really trailblazing by way of number one, decentralizing the site of the bar examination so that many of our poor students from the provinces need not come to Manila. You know how expensive it is just to take the plane, take some what they call this temporary dormitories here, and really get bothered to take the bar examination. And more so if you are a working student, did not have any more opportunity to really master the law when you were in 4 or 5 years in law school, and yet you have to go to Manila with barely anything at all except your guts and courage to take the bar exams. So the decentralization to the major areas in the Philippines, if I remember right, 31 testing centers, and this time using computers, log on. All of these were very tough, and considering lawyers are not noted for their skill in technology, especially computers, and considering also Associate Justice Leonen perhaps is not as old in order to have the guts to get into this, but he's also young, so he is readily adaptable to technology. He really is breaking the ice by way of introducing the online computer system for the bar examinations and allowed also uh, the decentralization of taking the bar. And can you imagine setting up all of those systems so that there are no leaks, there is speed in execution, and the 2 days, very, very short 2 days bar exams and bridge to only 4 subjects did work out. The second point I'd like to, of course, from my personal point of view, there are many of my professors who make the joke that I did not top the bar because my handwriting is really very bad. Among us, some of my professors have been very vocal about that probably if my handwriting was better, I would have been able to deliver the goods and perhaps made good in the bar exams. But among us girls, it is not true that my handwriting is that bad because I did practice for 2 months before the bar on how to, not that the long hand, but the printed answer which is acceptable. And so that therefore I know the examiners could read my handwriting. Perhaps my answers were a little aggressive and was taking so much risk in giving gray, areas that are not established in jurisprudence, but using, a little aggressiveness in the answers. That essentially would have cost me some good points that would have been easy, but were not given good grades. And this brings across the advantage of having computerized bar exams because you eliminate the factor of bad handwriting and, of course, bad eyes on the part of the examiners who are no longer very young lawyers. So you immediately eliminate that. And since I have been adopting also computerized online examinations for the College of Law students, it is very easy to assemble, the soft copies, put them side by side, and correct them as fast as you can. At the same time, you can have a standard answer, and therefore, everybody's paper was put side by side would readily be comparable to each other, so that there are no tendencies towards favoritism in the style of writing because you're only looking at the key points. I have another slide, another set of slides as a preliminary on how to pass the bar in terms of the mechanics of how to put your answers. That is also the other advantage when you are comfortable with computer systems. Then it is easy for you to really frame your answers so that they come in short with simple sentences and direct to the point, which probably you may not have the luxury when you are in effect ad-libbing in a handwritten examination. So with utmost sincerity, may I extend my sincere and personal professional congratulations to Associate Justice Marvin Leonel. On the side, we sat side by side during the series of examinations given by the Judicial and Bar Council when we were both considered in 2012 for the position that he now occupies. So without much ado, let me now proceed with the, I guess, 18 subjects or questions given on the first day, which was labeled laws relating to relationship of the citizen with the state. And they divided that into the 3 subjects given in the previous bar examinations. The questions on political law, which obviously would be covering the 2 major aspects of the Constitution, the Bill of Rights, and of course the government structure. And then the questions on labor, and then in taxation. Immediately, let me tell you that I zeroed in on what questions would have been given in labor and taxation. In all fairness, the questions, there were 3 questions in labor, and they were very, very fundamental, following the philosophy of Justice Lonen that this bar examination is entry-level knowledge of the law. And in fairness, even if the questions were reasonable to prove that a candidate to become a lawyer knows the basics. Those who did not study well will also not be able to answer even the basic questions given in labor law and also in taxation. So there were 3 questions out of the 18. No? So that means there were 18 questions all in all on the first subject in the morning of February 4. And of the 18, 3 were coming from labor and 3 were coming from taxation. So that's 18 minus 6, that's 12. 12 questions dedicated to political law. We will see in a little while the breakdown of the questions on political law. But in another set of uploaded slides, I have combined labor law and taxation. And the 3 questions on labor law were really fundamentals. Like there was a question on employer-employee relationship, I guess, in terms of illegal dismissal. There was also, if I recall right, the question on the right to self-organization of workers in non-governmental but cost-oriented groups. And then the other one had something to do, if I recall right, one is illegal dismissal and insubordination. The other one is on the period of probation of an employee. In taxation, it was even, as expected, taxation has always been a killer subject in the bar. But this time it was almost like a giveaway. The first question had something to do with, the second question had something to do with the donor's tax. There was an engagement ring given worth 1 million. So the question was, what would be the corresponding tax thereon? Very, very easy. The last one had something to do with the timetable of the submission of corporate income tax. And the 3-year period was the focus of that one. So if you are a bar candidate and you are not aware of the 3-year prescriptive period, then you're in trouble. But there's a booby trap because the taxable income was 2015, and therefore a careless bar taker would be starting to count the 3 years from 2015, 15, 16, 17. So you would say that on the 2017, then the 3 years has already elapsed, and therefore any tax assessment would have prescribed. The philosophy is correct. The counting is wrong. Because if the taxable year is 2015, which closes on December 2015, the taxpayer is required to submit his tax return on April 15 of 2016. The April 15 following the close of the December 31, 2015. So the 2016 is the filing, and the 3-year period is counted from the time of filing. So that will be 2016, 2017, 2018, 2019. So the prescriptive period will be on April 15, 2019. The assessment was issued January 2020. So obviously, the answer is very easy that the assessment can no longer be enforceable because it has prescribed. But the manner of explaining would really create some major deductions on the part of the candidate. And I'm sure many candidates would have made that mistake of counting 2015, 16, 17, 15, 16, 17, 18. And they would have said on April 16, 2018, there is already a prescription. No, you would have to add another year because the counting would start on April 15, 2016, not 2015. Anyway, without much ado, let us now go into the questions on purely political law, and there are 12 of them. And my approach here is to divide the questions on political law according to the major fields. Well, this one I have always put this up. Some of my own friends said, Dean, you really don't anymore have to advertise who you are. Many of us know you already, so you can skip this particular portion. But if you are a new subscriber to my 54 or I understand 56 topics already uploaded in YouTube, you would not know if you are new with my slides that I come from three major areas in academics, in corporate management, and in law. In academics, I'm both a certified public accountant and a lawyer, a member of the Philippine Bar. I hold also my master's degree in business administration. I have three schools. I came from UP, University of the Philippines, with a Master of Business Administration, and finishing with the Magna Cum Laude equivalent and also the class valedictorian. I came from UE with 2 degrees. My Bachelor of Laws is from UE, cum laude and class valedictorian. And my business administration major in accounting is summa cum laude. And I was a very active student there during my time. My high school is from the University of Santo Tomas Education High School. And I'm very lucky that even at this later age when we already belong to the alumni group, my alma mater, University of Santo Tomas, gave me three separate awards for being an outstanding alumnus. The University of the East recently just gave away Outstanding Alumni Award of the 75th UE anniversary. I was one of them. And of course, from the University of the Philippines, I have my induction into the exclusive honor societies Pi Kappa Pi and Pi Gamma Mu. In the corporate management world, I came from several multinationals. The reason their logos are here to give them recognition. Fuji Xerox in the technology and printing business, ESO Petron in the petroleum business, Motorola in the semiconductor business, and GlaxoSmithKline in pharmaceuticals. But there were other companies in between. But these are the major ones where I stayed long and as a significantly chief finance officer. Uh, I have also my stint with the graduate schools of De La Salle, MBA program in the University of the Philippines, about almost 37 years at De La Salle. Having become also a department chairman of the field of financial management. So I'm both in the field of law and also in the field of money, financial management. My entry into law school was very late. I became a lawyer almost before I became 50 years old. And I was the oldest in the graduating class, but graduated as class valedictorian and cum laude, and was of course expected to make good in the bar exams, but did not come out that way. Anyway, I am the incumbent dean of the College of Law of the University of Manila and vice president for legal affairs. I've been nominated twice, passing to the Judicial and Bar Council for Associate Justice of the Supreme Court, essentially in 2012 and 2016. Now, on the coverage of the subject on the laws relating to the relationship of the citizen with the state, in political law, there are two major fields that were given as expected: questions on Bill of Rights and questions on the government. On the Bill of Rights, let me see whether I have broken this up. Yes, in the Bill of Rights, the questions that were asked covered the freedom of speech, the Equal Protection Clause, and of course, the question on due process involving search and seizure operations. So there are about three questions in the Bill of Rights. And in government, to divide the government into the legislature, the executive department, the judiciary, and of course, there would have been two, the local government units, and the constitutional commissions. Originally, I had box circles for them, but there were no questions asked on local government and also not even in election, nor in what you would call this local government, local election, the other one I was mentioning. And so I already deleted that. Surprisingly, there are no direct questions to the legislature. There were a couple of questions, I think four about the executive department and about five in the judiciary. And so you can imagine the 12, you have here five, 4 plus 5, that's 9. And then you have about, on the Bill of Rights, about 3. So that essentially would be the totality of the coverage on the political law subject in the first examination day. On the executive department, there were questions on the president. There was a question on martial law, and there was a question on the right of media, plus the discretion in foreign policy. So there were 4 questions zeroed in on the executive department. In the area of the judiciary, the questions asked would be in the compensation for eminent domain, who has the authority over that, the authority of the lower courts to decide on the constitutionality of an issue, and then of course the legality of organizing the Supreme Court, on the issue of justiciable versus political question, and here is where divorce was asked. And then finally, the effect of Mandamus on the performance of discretionary powers. So, without much ado, let's go back to the Bill of Rights. The first question is on the freedom of speech. The question on freedom of speech ran this way. A law, that's problem number 2, a law is passed penalizing any criticism of any sitting member of the Supreme Court on any media platform. The penalty is higher than the criticism when the criticism is made through social media. The question is this law constitutional? Explain briefly. Our suggested answer, no, the law is not constitutional. No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievance. With utmost respect, I don't think there is any need to further explain Section 4 of Article 3 of the Constitution in answering the issue of whether or not there can be a law to penalize anybody who criticizes the Supreme Court. No one is above the law. No one is above the Constitution, and the Constitution recognizes by this provision the freedom of speech of individuals. Somewhere along the line, the only important thing here is because the Supreme Court would be the weaker or the weakest of the 3 branches of government. The strongest is, of course, the executive department with the armed forces of the Philippines and the Philippine National Police. And the Congress of the Philippines, I guess by sheer numbers, they would be very strong. But when you have only, 15 members of the Supreme Court, and they can be clobbered with a lot of criticisms, somewhere along the line, they have nothing else to defend themselves except the beauty and defensibility of the decisions they make. However, having said that, they are not exempt from any criticism after they make their decisions. Of course, along the line, the criticisms need to be courteous enough in order to give the respect that they deserve. Otherwise, if the criticism becomes vicious, then the issue of contempt of court can still be brought into focus. Moving now to the second question regarding the Bill of Rights, it has something to do with the Equal Protection Clause. And this is very interesting, and this is based on an incident that happened in the courts in Quezon City. Let's take a look. Under the Equal Protection Clause, the problem reads, the executive judge of a regional trial court prohibited the conduct of daily prayers for Muslims inside any room of the Hall of Justice even during break time. Among Muslims, 5 daily prayers or salah are mandatory. In all these daily prayers, Muslims need to face the Qibla. There is a noontime prayer Zuhr and an afternoon prayer Asar, but unlike the other three prayers, these two can be recited silently but still on a prayer mat and with body movements. There is a Supreme Court resolution that allows Catholic masses to be held during break time inside halls of justice. There was only one dissent to this resolution on the ground of strict separation of church and state in relation to acts of worship. The executive judge is a member of a Catholic institution perceived to be conservative. Did the executive judge violate the Equal Protection Clause of the Constitution? Explain briefly. Our suggested answer: yes, the judge violated the Equal Protection Clause. The state is to exercise benevolent neutrality concerning the freedom of religion with no discrimination or preference. The judge showed discrimination against the Muslims' daily prayers where Catholic masses are allowed in the premises. This incident did happen and can be quoted under the letter of Tony Q. Valenciano, the holding of religious rituals at the Hall of Justice building in Quezon City, an administrative matter that was decided by the Supreme Court on March 7, 2017. Very, very recent. Also, on the discrimination and equal protection, the Ladlad Party versus Comelec is a classic example where the Supreme Court took issue on the need for equal protection, even among those who may not be purely male or purely female in their personal disposition. So the answer is yes, the judge did violate the Equal Protection Clause. And the last question about the Bill of Rights is the due process in the matter of warrantless search and seizure. In here, the problem reads, as a car driver was getting into their car inside the parking area of a mall in Makati, 2 individuals suddenly came from behind them. One pointed a gun to the car driver's head while the other grabbed the car keys in the driver's hand. The two then sped away with the car. After recovering from the initial shock, the driver took their smartphone and opened the app, quote, Find My Car, close quote. Find My Car is an app that tracks in real time the movement and location of a car through a global positioning system, GPS, device installed in the car. Driver then went to the nearest police station and showed the officers the current location of the car as shown in their smartphone. The car appeared to stop at a spot in Novaliches, Quezon City. 6 hours after the car had been stolen, a combined team of elite police force officers from the Highway Patrol Group and the Criminal Investigation Detection Group, by force and without a warrant, searched a private home in Novaliches, Quezon City. The private home was pinpointed by the car's GPS tracker as displayed on the driver's phone. The private home is enclosed by a gate and is equipped with security cameras. In the private home's garage, the police officers found the driver's car along with 2 other cars which match police records of previously stolen motor vehicles. The officers seized and impounded all these 3 cars. Right then and there, they also arrested the owner of the private home, who was subsequently charged with carnapping. Are the seized cars admissible in evidence? Explain. Our suggested answer: no, the cars are not admissible in evidence. No person shall be deprived of property without due process of law. Any evidence obtained without the lawful order of the court is inadmissible for any purpose in any proceeding. So this is our suggested answer. But this answer, in the future, may be subjected to modifications in the implementation of the law. In the United States, there is this doctrine called the indispensable discovery, where a police officer may in fact take hold of a property that was the subject matter of, say, theft or robbery, even without a warrant. If it can be proven that even when there was a warrant that were to be issued, the mechanism available to already pin down the item to be seized can already be discovered. In other words, if it doesn't matter whether for example, in this case, the car that was carnapped could have been identified and found when there is a court-issued search warrant, versus in that case where there was no search warrant. But the mechanism of trying to pinpoint that car, whether with the use of a search warrant or with that so-called almost like a situation of hot pursuit operation, the available technology, which in this case is the global positioning system or GPS with the app Find My Car, would have been the same technology that would have allowed the police officers to keep track of that particular vehicle. And so under the indispensable discovery doctrine in the United States, no jurisprudence yet here to adopt that. But you know how it is. If it's a jurisprudence in the United States, it can be picked up somewhere here by some lawyers and presented it also in a triable case. And so if the technology would have been available both for the non-existence of a search warrant, or when there is a search warrant, you would use the same global positioning system or GPS, then it would become moot and academic that the property was taken or was seized even without a search warrant. So that is the beautiful thing about this. So if this were to be given again, who knows, 5 years from now in the bar examination, the answer, the official answer would have been already different. So that essentially would comprise the 3 questions asked in political law, in the law of the state, covering the Bill of Rights. There would have been more, but following the philosophy of Justice Leonen, he feels that perhaps these 3 questions would have been so fundamental that no person, no law graduate should pass without at least understanding these three. That is the way we read this particular thing. So from the Bill of Rights, the next area that was covered by the bar question on political law was the setup of government, which is the second portion of the Constitution. You know, if you really look at it pragmatically from the point of view of a graduate of law who will try to break out the Constitution, there are only really two major components. The Bill of Rights representing all the human rights that the citizenry, the people, never delegated to their state when they organize, the state by way of people, territory, government, sovereignty. They said, you can run everything, we will delegate it to you. But we are never surrendering our human rights, and that is in the Constitution. That is the first part of the Constitution. The second part, the people said, this is how we would like our government to be set up. And so there are three areas, three major divisions of the powers of the sovereign powers of government, and there was no question asked on the legislature, but there were questions asked on the executive department. Let's take a look at it. So in the executive department, there were 4 questions asked, and the first question had something to do with the presidency. The question on the presidency is fundamental. Can a charismatic and effective 30-year-old mayor of a chartered city in Metro Manila legally run for President of the Republic of the Philippines in the 2022 elections? Explain briefly. The suggested answer, no. The former mayor cannot run for Philippine president because he needs to be 40 years old on election day. He also should be natural-born citizen of the Philippines and a resident of the Philippines for at least 10 years immediately preceding such election. A mayor can be a resident of the place where he is in the Philippines for a lesser period. So that therefore it would have to be emphasized that if he runs for the presidency, he has to have a 10-year residency here in the Philippines. Of course, the major question is 30 years versus the required 40 years. So that was the first giveaway question in the government setup, executive department. The second question that was asked about the executive department is in the question of martial law. It says, to obtain the spread of a virus and in line with the World Health Organization's declaration of a pandemic, the President declared martial law throughout the entire Philippine archipelago. As an additional justification, the proclamation declaring martial law cited the possibility that health protocols might not be followed. A law student filed a petition before the Supreme Court questioning the sufficiency of the constitutional and factual basis for the martial law declaration. Does the law student have standing to file this action? Explain briefly. This question can be very dangerous because the bar candidate, may be looking into the reason for martial law. And, invasion, insurrection, and so on and so forth. And the declaration here had something to do with the pandemic. And so he probably will argue along those lines. And if he did, he missed a very basic technique in the bar examination and also in the practice of law. When you are in the practice of law, there can be so many angles that your client may be talking about. And yet you finally go to the fundamental question of what is the right of this particular individual that is being violated. So this question zeroes in on what is the right of this law student, to question the declaration of martial law. It is actually asking whether he or he cannot question the decision to declare martial law. It had nothing to do with the reasoning of martial law because that would come in much later if he had the legal personality to act. And so your answer here would have to revolve around this simple question. Does the law student have standing to file this action? And so your answer is either yes or no. Our recommended answer is yes. The law student, as a citizen, has the standing to question the constitutional and factual basis for the martial law declaration. That is what the Constitution provided. Any citizen, so that's the key, can question the legal basis, legal and factual basis of declaring martial law. Ganun kasimple. So you notice the question can be tricky. The answer is so short. Mahaba pa yung question kesa dun sa answer. Okay. And that is what I think the examiners are expecting, brief, direct to the point answers. Kasi pagka humaba pa yan, ibig sabihin, the candidate is nambobola na at hindi niya sigurado yung kanyang answer. That is the danger of kilometric answers. It manifests that the bar candidate is not sure of his answer. And so he would probably put one paragraph to explain why his answer is yes, and a second paragraph, however, where he now argues in favor of an answer which is no. Historically, we have already been saying in the bar review that no bar candidate should take that position because the bar examination is testing whether or not you know the law. But if you hypothesize that according to Tolentino, for example, paragraph 1, which is answer where the answer is yes, is valid, but according to Ambrosio Padilla, second one, it is no. You don't argue with that one. In fact, one rumored summa cum laude in the College of Law failed the bar 3 times to the embarrassment of his law school. And so finally, his law school petitioned secretly the Supreme Court to share his paper on the 3rd attempt where he also failed. Ganun daw ang ginagawa. According to Tolentino, ito sagot sa civil law. According to Ambrosio Padilla, ito, which is the opposite. And according to me, and because I'm better than the two, this is it. And that is how not to pass the bar examination. So, never, ever give, that kind of posturing where you have really 2 sides of the issue being reasoned out. You just take a stand, and you take a stand on the basis of the clear intent of the law and supported by any decision that is already obvious. The third question that was asked about the executive department is the issue of whether or not media can be participated in by foreigners. So let's take a look. The question: a news agency incorporated under Philippine laws won 2 international awards for its stand on freedom of expression. One of its founding directors even won the Nobel Peace Prize. For championing free expression, it received a substantial investment offer from a British philanthropist. The investment offer comes in the form of funds which can cover at least 80% of the news agency's operations, both in print and online. In exchange, however, the British philanthropist would acquire 51% of the news agency's outstanding common and voting stocks, as well as get a seat for the philanthropist's nominee in the news agency's governing board. Are the conditions of the investment constitutional? Explain. Our suggested answer: no, the investment conditions are not constitutional. Only Filipinos can utilize natural resources, operate public utilities, and engage in nationalized industries, including the ownership and management of mass media. So that therefore, this particular provision of the Constitution and also opinion of the Supreme Court and the SEC are binding. Mass media cannot have any foreign investments. However, if you borrow the concept from corporation law on the question of whether or not a corporation can participate in in nationalized industries mentioned here. No? Natural resources, public utilities, nationalized industries including mass media. The answer is if it were a corporation and the corporation has 60% Filipino, then the 60% would be equivalent to 100%. And so a corporation with a natural persons holding 60% of its voting stock would be qualified to participate in what we call the nationalized industries, including media. And so that means the question would be, if you are a corporation and you are all Filipinos, then you can participate in mass media. But if you are only 60% Filipino and 40% foreigner, the 60% will still qualify you to in effect be considered 100% Filipino. In this particular case, the foreigners are already 51% and only 49% of the required 60% referring to Filipino shareholdings would be satisfied. So the answer is no. The investment will not be allowed to engage in mass media. And the last question on the executive department is on the question of discretion in foreign policy. The question is, the United Nations General Assembly unanimously passed a resolution expressing the commitment of its members to pass laws and related policies that would provide incentives for all citizens of the planet to change their lifestyle so that the impending disasters brought about by climate change can be avoided or mitigated. As the principal legal advisor to the Secretary of Foreign Affairs, you are asked this query. Is this General Assembly resolution a valid source of state obligation under international law? Explain briefly. I have been dwelling on this particular question for quite a number of hours. And the other night, it was already a little past 12 midnight, and I was feeling tired going over these questions. And so I brushed my teeth, did my washing of my face, and was preparing to go under the bed sheets. When I was about to do that, suddenly in my mind came, so suddenly, pacta sunt servanda. And I know somebody was trying to whisper to me, pacta sunt servanda, about 3 or 4 times. And there is only one person who introduced to me the concept of pacta sunt servanda. My beloved professor in political science too, when I was 16 years old. And my dean in the College of Law of the University of the East, and my professor in both public international law and conflict of laws. My dear friend and my benefactor, my idol, Dean Celedonio Johnson. And when I kept hearing in my ears, pacta sunt servanda, I had to smile. I had to take a few silent moments and say, Dean Johnson, marami pong salamat. Naalala niyo pa ako. Binulungan niyo pa ako sa problem na ito na pacta sunt servanda. That is why I believe, the souls of our friends, of the people who care for us and we care for, would still be around. And I'm wondering about, of course, those who are so close to me, those who are dear to my heart. Yan. Si Dean Celedonio Johnson, for which my lecture on conflict of laws was dedicated. Then Goa Doctrine, and so on. Tapos yung UN General Assembly Double Veto. Puro, at all the provisions of the Bill of Rights under the 1935 Constitution, I can almost recite verbatim the lectures of Dean Celedonio Johnson. And I will never forget, when I went into UE Law to enroll, he was so shocked because he was giving me already a teaching load. I was already 40 years old and therefore I should deserve to teach. And when I finally told him, Dean, okay lang po, magtuturo ako, but can you do me a favor? Can you allow me to finish first my Bachelor of Laws? And he looked at me and he said, ano? Ilang taong ka na? Hindi ka pa abogado. And he remembered. I was his student 25 years before that. And he never forgot. I was one of his better students. And he expected me to be a lawyer, and there I was. I was past 40 and applying to be a law student. And so he looked at me with a naughty smile and said, andyan pa ba yung utak mo nung ikaw ay maging summa cum laude 25 years ago? And I said, tingnan ko po sir, baka sakali pong andyan pa. And every semester when he meets me in the corridor, he would say, andito ka pa? Because in their experience in the College of Law, most of those who are occupying good positions already in the private sector employment would normally not last second year. Madalas first year bumibitaw. Kaya ako, naka-4 na semester na, nakikita niya sa ka-corridor, andito ka pa. Third year, 2 semester, nandito ka pa. Pagdating ng 4th year, andun pa ako kasi estudyante na niya ako sa conflict of laws tsaka sa public international law. Obviously, he cannot naman drive me away. O nandito ko pa, 4th year. And so when I recited Renvo Doctrine, in the board, and he looked at me and he said, as a side comment when we were about to go home, Suma, mukha atang pwede ka pa. Ano ba yan? Tuloy-tuloy na ba sa bar yan? And I will never forget him. He's a very good friend of mine. Isa pa mga kaibigan ko na siyempre hindi ko makakalimutan, si Mayor Alfredo Sioholin. Another fellow na talagang mga elders ko yan. Ka-generation niya ng lolo at father ko. And yet, I became very good young protege nila. So, balik tayo dito. Ano isasagot natin dito? Yan daw bang United Nations General Assembly na may resolution? Would that be a source of state obligation under international law? This is our suggested answer. Yes, the General Assembly resolution is a valid source of state obligation under international law. The Philippines adopts the generally accepted principles of international law as part of the law of the land under the principle of incorporation. States are to comply with the object and purpose of a treaty by reason of the Pacta Sunt Servanda Doctrine. Kamusta po, Dean Johnson? A treaty is binding upon the parties to it and must be performed by them in good faith. And continuing now, it says, let me just bring this down. States, this is not anymore included, hahaba na ang sagot, but this is an option. States may not invoke restrictions imposed by domestic law for not complying with the treaty obligations when said treaty was duly ratified by competent authorities and in accordance with constitutional and statutory requirements. No? And this is with tremendous authority. This is Section 2 of Article 2, the area of adoption of general accepted principles, the Charter of the United Nations, the Covenant of the League of Nations, and Article 26 of the Vienna Convention on the Law of Treaties, demands or demand that states should normally comply with their commitments in their treaty agreements. Okay. So that essentially covers the questions on the executive department, four of them. Finally, the questions that have something to do with the judiciary. Eminent domain, the authority of the lower courts to declare a law unconstitutional, the organization of the Supreme Court, the question of political issue versus justiciable issue, and the exercise of discretionary powers subject to Mandamus. So, question number 15 of the bar examination ran like this. And this was question number 3 actually. A law is passed which provides that when the Department of Public Works and Highways expropriates property for the government infrastructure projects, it will have the sole and exclusive authority to determine the price to be paid as compensation to the landowner, which amount shall be no more than the assessed value of the property used for real property taxation. Is this provision of law valid? The law is giving absolute authority to the Department of Public Works and Highways to determine the price. The question, is that provision of law legal? Our suggested answer, the determination of just compensation is a judicial function at the discretion of the trial court. Just compensation is the fair and full value, full equivalent of the loss suffered by the owner, whose property was taken to the state's power of eminent domain. It is the full and fair equivalent of the property taken from its owner by the expropriator, real, substantial, full, and ample. The property's fair market value is the just compensation representing the price, legal trade, and competition. From legal trade means and competition. Continuing. The property's fair market value is the just compensation representing the price agreed on by a willing buyer and a willing seller, both not compelled to enter into the transaction, fixed in the open market in the usual and ordinary course of legal trade and competition. So that is the fundamental rule that it is not, the public works and highways cannot determine, as a matter of a binding agreement, the market price. And this was decided in a series of cases. National Transmission Corporation versus Automobile Development, Leica Realty Corporation versus the Republic of the Philippines, Napocor versus Spouses Igmedio, and the Republic of the Philippines versus Spouses Cancio. All of those decided by the Supreme Court. I guess this is the fundamental. It cannot be the Department of Public Works and Highways that would determine. It will be the courts, because the courts will be disinterested parties in resolving how much is fair market value based on facts, of course. And normally they have a blue book here that they follow from the Bureau of Internal Revenue, which considers the latest sale of a comparable property within the same environment or the same place where the property being expropriated would be subjected to. No? Yan ang nagiging rule dyan. There is of course a fine point concept that if the need to exercise eminent domain involves critical national matters like, for example, national security, things that are really so evident. Then the state now can take over without any in expropriation, without having to pay just compensation by invoking the very fundamental Regalian Doctrine. So remember, under the Regalian Doctrine, all of these properties were supposed to be part of the king's privileged properties, and therefore that belongs to the state when the concept of royalty became passé. Yung daw Pilipinas, by reason of the Italiano royalty, sila may-ari ng buong Republika ng Pilipinas, even greater, no? Ma'am Saba, kasama yung Sri Visayan Empire. May mga gold daw sila, yung napahiram, 600 yata, pounds ng gold, pinahiram sa Vatican, binawi, no? Merong attorney's fee, apparently 15% si Ferdinand Marcos. Kaya sinasabi nila, meron daw naman talagang property bago pa raw napangasawa si Imelda. Marami raw dito. Sabi naman ng iba, wala namang historical documentary basis yan, pati yung Italiano family, sabi nila, no? Kaya ngayon, bakbakan yan. Kaya sinasabi, pag nakausap mo yung mga kampi kay Marcos, sasabihin na, wala naman silang mapatunayan talaga na nagnakaw kasi may kayamanan na yan before. Ito hindi ko maintindihan. When they're saying the gold were lent to the central bank on a 50-year agreement, natapos na yung 50 years, 2005 yata. Ba't hindi na lang tanongin yung central bank? Nandiyan ba yung ginto? Kung nandyan, di may answer na. Wala namang ganong ginto na hawak ng central bank, di tapos na rin. The other thing that I was reading some of their notes, may mga binabanggit ng mga cronies daw na bumaligtad na, sinurrender na yung yan, si Jose Yao Campos na United Lab, nabanggit yung si Rolando Gaffo, meron pa mga ibang binanggit. Pero kung totoo may mga ganong cronies, ba't yung hindi cronies naman? Ba't hindi tanungin? Pinakamatindi dyan, yung triumvirate from the University of the Philippines. Daldal yung mga taga School of Economics. Kapitbahay nila, mas reputable sa kanila. Unang-unang reputable na nandun sa tabi ni Marcos all throughout. Ang pangalan ay Cesar Emilio Aguinaldo Birata. Cesar Birata. Si Cesar Birata, up to now, ang reputation is malinis, hindi gumawa. And he's been very silent. And, he will not last very long. Ba't hindi nila tinatanong siya? Matino siyang tao. Sir, ano ba talaga ang katotohanan? Nagnakaw ba o hindi? Meron pa siyang dalawang assistant na nandun din. Kinuha rin mula sa UP Diretso. Yung isa si Jaime Laya, naging governor ng Central Bank. Ba't hindi tanungin? Diretso. Dahil sinabi yung gold nandun sa Central Bank. Sir, ikaw ba governor ng Central Bank? Nandun pa yung gold at yung ba talaga kay Marcos? Pinahiram lang sa gobyerno. Finally, yung budget officer na all of these monies could not have been siphoned off without him knowing. Si si Dr. Manny Alba, who was the budget minister. Tatlong mga pillars ng UP College of Business Administration. Si Manny Alba, naging professor ko pa, napakagaling na tao. Biro mo, sa tatlong na triumvirate, isa lang siya nakilala ko na alam kong matino, hindi tao saan. Si Cesar Birata, ultimately nakilala ko because he was working with Yuchenko and he was a member of the board of the directors of Judiciary, where I was the executive VP. At my only chance to meet him personally, professor ko yung kanyang kapatid sa UP, si Nestor Birat. Napakagaling na tao din. So sabi ko, sir, matagal na kita akong gustong ma-meet. Ako naman isa sa mga surot doon sa UP at teritoryo mo. Sabi niya, alam niya ang pangalan ko kasi I am the executive VP where he is the board, member of the board. So sabi niya, ako sir, UP ko ako. Sinong dean mo? Sabi ko, si Dean Manny Velasco. Oo, sabi niya na si Manny, oo. Nagturo ka ba sa UP? I know that is a loaded question. Kasi kung magaling kang UP product, no, yan ang marka mo. Kukunin kang professor sa UP. Sabi ko, opo. I was a professor in financial management from 1975 to 1985. Oh, hindi ang ganda ng ngiti sa akin. Sir, gusto ko lang ibulong sa inyo. Many people really love you because kayo lang ho hindi nababanggit na nagpayaman doon sa kung kayo nagtatrabaho kay Marcos. Yung bahay daw ho nyo na gano'n na itsura nung kayo kinuha ni Marcos. Hanggang ngayon, ganun din pa rin ho. Wala ho talagang kitang-kita, hindi kayo nakinabang. Sir, can I express my heartfelt appreciation for you being a very good and faithful Filipino. Ay nako, ang ngiti ng matanda. Siguro ako lang ang nagsabi sa kanya ng harap-harapan ng gano'n. And I appreciated his effort on that. Si Jimmy Laya, hindi ko pa nakakausap. Another one na wala namang masamang tinapay. Ba't hindi silang tatlong tanungin? O kung sino-sino yung mga pinakikinggan na hindi mo malaman kung gusto lang malibre makulong sila. Yung mga yan, talaga ba't hindi nila tirahin kung kumuha ng pera si Marcos? Dapat involved sila. May conspiracy dahil sila yung humahawak ng finances ni Marcos nung panahon na yun. Anyway, talaga ang buhay. Now, the second question involving the judiciary, and this is a classic question na even as lawyers have always asked questions on this one. And this is on the authority and jurisdiction of the regional trial courts to render a decision on the constitutionality of certain laws or something like that. The problem reads, a provincial ordinance was passed setting a province-wide curfew for all minors. This was challenged through a suit filed before the regional trial court having territorial jurisdiction over the province. The provincial legal officer sought the case dismissal on the lone ground that the Supreme Court has sole and exclusive jurisdiction to determine the constitutionality of a treaty, law, or ordinance. Should the provincial legal officer's prayer for dismissal be granted? Sabi niya, wala namang authority yung yung tawag dito, yung regional trial court na yan to determine kung yung provincial ordinance constitutional or not. Dapat ipanik mo yan sa Supreme Court. What is the correct answer? The correct answer is no. The legal officer's prayer for dismissal should not be granted. The RTC has jurisdiction to resolve the constitutionality of a statute, presidential decree, executive order, or administrative regulation subject to appeal before the Supreme Court. Alam niyo dito, mayroong isang decision dito, yung Philippine Migrants' Right Watch versus Overseas Welfare Workers Administration, decided in 2014. And the ponente is no less than Chief Justice Diosdado Peralta before he became the Chief Justice. At dito sinabi na the authority given by the Constitution on the interpretation of the Constitution is not limited to the Supreme Court. Sabi niya, it covers all the courts under the Constitution. However, if a lower court, like a regional trial court, should decide on the constitutionality of a law, whoever is the interested party can go up to the Supreme Court on appeal so that the decision of the Supreme Court on the constitutionality becomes final. Para bang gamit no regional trial court, Supreme Court din naman na magdidetermine. Ang ganda ng paliwanag ni Justice Dado Peralta. Sabi niya, the Supreme Court is not a trier of facts. And so if the courts all over the land are not allowed to decide on the constitutionality, then who will determine the facts of the issue? And so the concept is the trial courts would receive the issue on constitutionality based on the facts that are submitted to it and makes a decision. So that when that particular issue is brought ultimately to the Supreme Court would simply rely on the appreciation of the trial court on the facts itself. And so yun ang napakaganda na even in my case, I kept doubting for so many years, even when I became a lawyer. Because I have certain issues where I would like to raise the constitutionality issue of certain laws. No? And so I don't know. Dahil sabi, when you raise a constitutional issue, you should raise it at the earliest possible time. May danger yan. Kung hindi ka naniniwala na pwede mo i-bring up on trial before the regional trial court, di kailan mo i-bring up yung pag nag-appeal ka na before the Supreme Court. Conceptually, it will be already too late because you had the opportunity to bring it up before the trial court. Pero itong problema, siguro 9 out of 10 judges would look at you and say, bakit sa akin mo tatanong yung constitutionality? Hindi naman ako Supreme Court. Ganon ang tendency ng mga trial courts. No? And the decision of the Supreme Court on the Philippine Migrants' Right Watch and emphasized now in this particular bar examination and amplified by the suggested answer. Ang sinasabi ng Supreme Court, resolved na yan. Kayong mga trial judges, you should receive issues on constitutionality. And then you determine the facts. And on the basis of your determination of facts, dahil marunong naman kayo ng batas, kayo expert sa batas din na katulad namin, you resolve the constitutionality. And so, pagdating sa amin, titingnan lang namin kung may basihan yung kanyang conclusion and then we just affirm. No? Ngayon, kung talagang very interesting ang debate yan, hindi kami maghihimay ng facts. It has to come from the decision that you made. Ang ganda-ganda. And right now, I have some very critical issues involving constitutionality. No? Isa dyan, ipapanik ko na yan. Yung issue ng extrajudicial foreclosure of mortgage. Alam nyo, sa judicial foreclosure, may proseso binigyan ng shortcut, nagkaroon ng extrajudicial foreclosure. Wala nagre-reklamo kasi those who are debtors, kaya naman naiipit yan, foreclose, walang pera. Tapos pinurclose, wala na nga silang pambayad, lalo walang pambayad sa abogado. But I am handling one particular case where the one involved is my own younger brother. At tingin ko, inabuso yung kanyang karapatan. Engineer, hindi naman marunong ng batas. So para makabayad sa pinagkakautang bangko, kukunin na rin niya yung portion ng kanyang share ng estate ng parents ko. Sabi ko, wala tayong pera, ibebenta natin ang property. And if we sell it at a distressed price, hindi lang ikaw ang lugi. Kami dalawa ng kapatid natin malulugi kasi siyempre, bebenta mo ng mura. Doon sa loss mo doon, no, against market, share kami doon. Nababawiin mo naman doon sa share mo, doon sa dalawang properties pa naiiwan. Pwede mo pag-aralan ko yan. From the point of view of procedures, ang dami-daming mga loophole. Saan ka nakakita ng ancillary contract of real estate mortgage dated prior to the loan agreement and the promissory note? Di ba yung principal contract ng loan agreement at yung promissory note? Dated 10 days after nag-real estate mortgage. So anong gagawin nung sheriff o sa foreclosure proceedings? Di dapat tingnan niya muna kung valid yung real estate mortgage. If it is dated before the principal obligation, hindi pwede. Tinanong ko yung sheriff by way of an interrogatory. Hindi rin nila tinitingnan yun. Ang presumption of regularity. Nak ng kamote, ano pang papel nila? Sasabihin lang ng bangko, foreclose mo to, i-deed of sale. You are performing what you call this, an administrative ministerial duty that you have to follow certain rules. Inutos sa'yo, gagawin mo na lang. Hindi you will already bang your head against the fundamental constitutional principle of no person shall be deprived of property without due process of law. O, member ka ng Philippine Bar, o under ka ng Supreme Court, no? Pagkatapos bibira ka lang ng bibira, foreclosure, o dahil kaibigan mo yung taga-bangko without even looking into the documents, hindi pwede. I'm raising this issue and this will reach the Supreme Court because the unconstitutionality of the extrajudicial foreclosure as it is being carried out now. Walang komisyon yan kasi ang napakalakas na partido parati yan yung may pera, nagpapautang. Sino nagpapautang? Yung mga bangko. Sino na po foreclose? Yung mga walang pera, nawalan ng trabaho, minalas, and so on. Wala, kawawa, walang abogado. Nagkataon, exception yata yung sitwasyon ng kapatid ko. Wala rin naman siyang pera, gipit siya. Pero napatunayan ko based on fundamental accounting, overpaid siya. Tapos foreclose yung kanyang property na wala namang valid real estate mortgage. Anyway, interesting. I hope I am not what we call this be sued for trying to discuss the merits of the case. Nababanggit ko lang by way of principle. Okay, next would be in the matter of so doon, merong authority at merong obligasyon yung lower courts to decide on the constitutionality. Next, the organization of the Supreme Court. Here is the problem. Both the House of Representatives and the Senate passed a bill which A, increases the number of Supreme Court justices from 15 to 20. B, assigns the 5 most senior justices, including the Chief Justice, exclusively to a special division that will tackle only constitutional cases. And C, removes from the Supreme Court and bank the power to hear and decide cases involving alleged violations of the Constitution. The Chief Presidential Legal Counsel advises the President to veto the bill, arguing that the law is unconstitutional because its content should be the subject of constitutional amendment rather than of legislation. Is the Chief Presidential Legal Counsel's argument constitutionally sound? Explain. Beautiful. Our suggested answer, yes. The legal counsel's argument on the constitutionality is sound. No law shall be passed reorganizing the judiciary when it undermines the security of tenure of its members. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. The legislature cannot be involved with the judicial functions because of the principle of separation of powers. Dito, pakikialaman ng legislature yung paano magpa-function ng Supreme Court, pati yung assignment ng justices. Malinaw ito, this is not in accordance with the intention that the 3 branches of government, the legislature, the executive department, and the judicial department are co-equal. And so that therefore, there has to be no meddling in the way one functions versus the other. And definitely, Congress cannot meddle with the way the Supreme Court has been organized under the Constitution. Tama yun. It is only a constitutional amendment that can change the Supreme Court. Next, the issue of justiciable versus political issue. This is problem number 10 in the bar examination, and it reads that both houses of Congress are seriously debating a bill seeking to enable absolute divorce. A citizen filed a petition asking the Supreme Court to order congressional deliberations to stop. Should the petition prosper? Explain briefly. Our explanation. The petition to stop the debate on the divorce cannot prosper. Judicial review is limited to actual cases and controversies decided by legal principles. The Supreme Court cannot be involved with a political meaning policy question, which the people decide in their sovereign capacity, dependent upon their wisdom and not on legality. The Constitution delegated to the legislature the full discretionary authority to decide a political or policy issue to include divorce. So ito makikita nyo, pinag-uusapan divorce. Pero kung pinag-uusapan a policy issue on how to run our families, that cannot be justiciable by the Supreme Court. When we use the word political issue, we do not mean politics. What we mean by a political issue that the Supreme Court cannot be delving with, if it is a question of policy. And what is policy? Policy is what the people intrinsically think. Kaya sabi rito, these are the issues where the people decide in their sovereign capacity. Sila yung sovereign people. No? And therefore, what is needed is their wisdom. Hindi yung legality ng issue. Kasi legality, courts yun. Na-establish na yung rule, yung batas. Pero kung wala pang batas at sinasabi anong direction natin, anong gagawin natin, anong ating vision, anong ating mission, anong ating kagustuhan na mangyari bilang mga tao, no? Iyon ang tinatanong doon, yung wisdom. Kaya yung divorce, wisdom, that involves wisdom. Kasi there is one side na marriage is sacred, inviolable. Yun ang hypothesis ngayon ng family code. Pero that is a policy issue that has been resolved by the people by the enactment of the family code. But the people themselves, we can probably say, bakit ba gusto natin permanent ang marriage? Ba't hindi natin nahayagan yung mga tao magdesisyon? Tayo magdesisyon kung gusto natin permanent o hindi. Bakit yung lahat ng bayan, except the Vatican, lahat sila nire-recognize na pwede maghiwalay ang mag-asawa by way of a divorce and dissolve the union. Tayo, sabi natin, hindi. Parang tayo minority sa buong mundo. Why don't we also follow that same philosophy? No? So yun, it's a policy. Anong kursunada natin? Kaya hindi pinag-usapan ng legality yung wisdom na gusto ng mga tao. And so that particular thing is not subject to the jurisdiction of the Supreme Court. Kaya pag nag-file ng kaso to petition the Supreme Court to order the Congress either to approve or disapprove or to stop the debate, that is beyond the jurisdiction and nature of the Supreme Court. Okay. And finally, the question on the exercise of discretion in government. This is problem number 11, and this would be the last question in the subject matter of the judiciary and also in the bar examination on political law. The question reads, a senator filed a petition for Mandamus to compel a newly elected president to sign, approve, and transmit to the Senate for its ratification the treaty creating the International Criminal Court. Should this petition prosper? Explain. No, the petition should not prosper because Mandamus cannot compel the president to perform a discretionary power. Whenever a statute gives discretionary power to any person to be exercised by him upon his own appreciation of certain facts, such statute constitutes him the sole judge of the existence of those facts. Discretion, when applied to public functionaries, means a power or right conferred upon them by law of acting officially under certain circumstances according to the dictates of their own judgments and consciences, uncontrolled by the judgments or consciences of others. Mandamus will not lie to control the exercise of discretion. The issue of discretion has been addressed as early as 1936 by no less than Justice Jose Laurel, when he was the ponente in the case of Sanson versus Sanson. Very interesting And it is very rewarding to read the decision of Justice Jose Laurel as early as 1926 na doon po pala pinag-uusapan yung discretion, you know. Okay. And so also, this was the subject matter of Barcelona versus Baker and Doe Thompson as early as the Philippine reports of 87. And there were other cited cases. Well, ladies and gentlemen, that essentially is our bar examination on the law of the states in relation to the individuals, except the 6 problems relating to labor and taxation that will be handled by an up and coming what they call this YouTube upload. And so with this, we can see that Justice Loren was really dependable and candid in saying that this bar examination is for entry-level lawyers. The problems were not easy, but they were in the level of a requirement of knowledge of the law for those who want to be lawyers. Hindi naman po pwede maging abogado ka, wala kang alam sa batas. And these questions are testing the minimum entry level. Pag hindi mo alam yung mga sagot yan, siguro mag-aral ka pa ng konti para naman maging attorney at law ka. And so I'd like to sincerely congratulate Din Leonen because you know when he said the Leonen bar examination will be memorable, everybody was really, including the deans, were really cowering under fear. Nako, pahihirapan. Apparently, the COVID, must have given Justice Leonen 2 years to think about his positioning in history. Now he has taken a better perspective, trailblazing in computerized bar examination, trailblazing also in modifying. Wala nang bar top-notchers daw ngayon. Ngayon ang pag-uusapan ng performance ng law schools. Kung sino yung magagaling na law schools. At tama ito. Kasi ito, mga basic at fundamentals, yung mga law schools na nagtatap, no? Pero may mga candidates yun naman nila na hindi pumapasa. Mag-a-average out yan, makikita. Kaya lang, I continue to pity the working law students. Talagang 80 to 90% ng mga bumabagsak mga working students na walang oras. And I can say that I was a working student and I was an old working student by way of age. No? And so I appreciate yung hirap. So with this, we'd like to close our sharing with you on the suggested answers to the questions on political law as part of the law of the state in relation to the individuals. With this, nagpapasalamat po ako at maligayang maligaya na hopefully I am again back in circulation with a lot of things that were still to be discussed in the field of law. Napakadami pong naipon ng mga subject matter na i-discuss ko pa. At kung ito lang ang pag-uusapan, no, hindi ko na dadagdagan ng mga side comments at kwento, ubos pa rin ang oras. And I hope you don't mind. Once in a while, I make commentaries by way of the little privilege I exercise by being part of you in this get-together. Marami pong salamat and I hope to continue to expect you to watch for the subsequent presentations.